Pleadings. So what are pleadings? Pleadings are the written statements of the respective claims and defenses of the parties submitted to the court for appropriate judgment. First, let's talk about complaint, answer, and the defenses contained in the answer. Okay, what is a complaint? A complaint is the initiatory pleading alleging the plaintiff's cause or causes of action. What should the complaint contain? The names and residences of the plaintiff and the defendant must be stated in the complaint. It should also contain a concise statement of the ultimate facts constituting the plaintiff's cause of action. Ultimate facts refer to the essential facts constituting the plaintiff's cause of action, not evidentiary facts or legal conclusions. A fact is essential if it cannot be stricken out without leaving the statement of the cause of action insufficient. Okay, so a complaint is called an initiatory pleading because it is actually the first pleading that is filed in court. It is the pleading that initiates the civil action. Now, it is important to know the initiatory pleadings because there are certain requirements mandated by law to be complied with, such as a certification against forum shopping and payment of docket fees. If you remember on the topic jurisdiction over the subject matter and the nature of the action are determined by the averments in the complaint. Now here is a simple illustration of the filing of a complaint. The plaintiff files a complaint against the defendant. We will use this illustration as we discuss other types of pleadings. Okay, now after the filing of the complaint and service of summons upon the defendant, what shall the defendant do? The next pleading that we will discuss is the answer. The answer is a responsive pleading in which the defending party sets forth his defenses. Okay, so it may or may not contain a counterclaim. It may likewise be the response to a counterclaim or a cross-claim. Let's illustrate. So the plaintiff files a complaint against the defendant. Summons will be served upon the defendant, and the defendant shall file his answer to the complaint within 15 days after service of summons, unless a different period is fixed by the court. Service of summons is one of the ways of acquiring jurisdiction over the person of the defendant. It is in the answer where the defendant sets forth his defenses. Now let's talk about defenses. Defenses may either be negative or affirmative. A negative defense is the specific denial of the material fact or facts alleged in the pleading of the claimant essential to his cause or causes of action. An affirmative defense, on the other hand, is an allegation of a new matter which, while hypothetically admitting the material allegations in the pleading of the claimant, would nevertheless prevent or bar recovery by him. Example, plaintiff files an action for a defaulted loan against the defendant. A negative defense would be a specific denial. So for example, the defendant would say, "No, I did not incur the loan," and explaining that the transaction was of a different nature. So that is a denial or a specific denial. Whereas an affirmative defense would say, "Yes, I obtained a loan, but I have already paid it," or "it was already novated," or "it already prescribed." So there is a hypothetical admission, but the new matter would prevent recovery because, for example, the loan was already paid or it has already prescribed. So you see the difference? Okay, let's talk about affirmative defense. So the affirmative defenses include fraud, statute of limitations or prescription, release, payment, illegality, statute of frauds, estoppel, former recovery, discharge and bankruptcy, and any other matter by way of confession and avoidance. So again, in these cases, in affirmative defenses, there is a hypothetical admission of the allegations in the complaint, but the new matter would actually bar recovery because, again, for example, if the loan was already paid, then that would bar recovery. But it did not deny the existence of the loan. It actually affirmed that there was a loan, but it was already paid, or the action has already prescribed. So that is affirmative defense. Now let's talk about specific denial. A defendant must specify each material allegation of fact, the truth of which he does not admit, and whenever practicable, shall set forth the substance of the matters upon which he relies to support his denial. Where a defendant desires to deny only a part of an averment, he shall specify so much of it as is true and material, and shall deny only the remainder. So the first one was a specific absolute denial, and the second one is a specific partial denial. Now, where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made in the complaint, he shall so state, and this shall have the effect of a denial. And this is called a disavowal of knowledge. Insufficient denial or denial amounting to admissions. So if an allegation is not specifically denied or the denial is a negative pregnant, the allegation is deemed admitted. The doctrine is that what is required is a specific denial and not a general denial. This doctrine was first established by the Supreme Court in the case of El Jugar Filipino versus Santos Investments, where it held that defendant's answer, wherein it merely denies generally and specifically each and every allegation contained in each and every paragraph of the complaint. So that is the wording of the denial. It denies generally and specifically each and every allegation contained in each and every paragraph of the complaint. The court held that it is but a general denial. Why is it not considered a specific denial when it actually says that it specifically denies, right? The court held that it is not a specific denial because it does not deal specifically with each material allegation of fact, nor does it set forth the substance of the matters upon which the defendant relies to support his denial. Okay? It does not serve the purpose of requiring the defendant to make a specific denial, which is to compel him to specify the matters which he intends to disprove and disclose the matters upon which he relies to support his denial, thereby limiting the issues and avoiding unnecessary delays and surprises. So under the old procedure, the plaintiff was compelled by defendant's mere general denial to prove facts alleged in the complaint which the defendant did not even attempt to dispute. Okay? So the new procedure does away with that unnecessary burden. This doctrine has since been applied uniformly in a long line of cases. One important matter to consider is the disavowal of knowledge, which the rules allow the defendant to state in his defense that he is without knowledge or information sufficient to form a belief as to the truth of a material averment in the complaint. If the defendant so states, that is considered a denial. Now, the court or the Supreme Court has held that time and again, the court has stressed that an unexplained denial of information and belief of a matter of records, the means of information concerning which are within the control of the pleader or are readily accessible to him, is evasive and is insufficient to constitute an effective denial, and that the form of denial must be availed of with sincerity and in good faith, certainly neither for the purpose of confusing the adverse party as to what allegations of the complaint are really put in issue, nor for the purpose of delay. So again, what is required is a specific denial and not a general denial nor a negative pregnant. What is a negative pregnant? A negative pregnant is a denial pregnant with admission of the substantial facts in the pleading responded to which are not squarely denied. It is in effect an admission of the averments it was directed at. Stated otherwise, a negative pregnant is a form of negative expression which carries with it an affirmation or at least an implication of some kind favorable to the adverse party. It is a denial pregnant with an admission of the substantial facts alleged in the pleading. Where a fact is alleged with qualifying or modifying language and the words of the allegation as so qualified or modified are literally denied, it has been held that the qualifying circumstances alone are denied while the fact itself is admitted. If an allegation is not specifically denied or the denial is a negative pregnant, the allegation is deemed admitted. Okay, to emphasize, where a fact is alleged with some qualifying or modifying language and the denial is conjunctive, a negative pregnant exists and only the qualification or modification is denied while the fact itself is admitted. A denial in the form of a negative pregnant is an ambiguous pleading since it cannot be ascertained whether it is the fact or only the qualification that is intended to be denied. Example: plaintiff alleges that defendant misused more than 100,000 pesos placed in his trust in 1994. Defendant denies the amount was more than 100,000 pesos and he denies it was given to him in 1994. Thus, the defendant did not deny the misuse, just the amount and the date. This is a negative pregnant and it means that the allegation is deemed admitted because it is not considered a specific denial. Here is an illustration of an effect if there is only a general denial or a negative pregnant. So when the denial is a general denial or a negative pregnant, it is not considered a specific denial, and the allegations in the complaint are deemed admitted. When the allegations in the complaint are admitted, then there is actually no issue. And then when there is no issue, it can lead to summary judgment or judgment on the pleadings.